Alright, Subpart G, Rules Practice of TSA Civil Penalty Action, 1503-601. With the subpart apply with the civil penalty action requirement of the paragraph of A1 through A3 with the section satisfied with the alleged violation of the TSA requirement of the amount of controversy not exceed the $50,000 violation committed by the individual small business concerned, $400,000 violation committed by any other person. 3. A person charged with the violation required for the hearing in accordance with 1503 and 427 in the subpart, but the subpart does not apply with the adjunction of validity of the TSA rule or other requirements of the U.S. Constitution, Administrative Procedure Act, or any other law. 1503-603, Civil Separation Function. A civil penalty proceeding that include with the hearings prosecuted that only with the agency of the attorney, except for the consent of the other agency official with the permanent with the issue of the prosecuted civil penalties are on 1503-421. B. Any agency employed with engaged with the performance, investigation, prosecutorial functions, and civil penalty action must not, in this case, the factual related with the case, participate and give the advice for the decision, injunction, law, or by the TSA with the decision maker and people with consent of the counsel with the witness in the public proceeding. C. The Chief Counsel Agency is termed but not covered in paragraph B of the section of I with the TSA with the decision maker regarding the initial decision appeal with the civil penalty action with the TSA decision maker. 1503-605 with appearance with the right of parties. Any party may appear with the be heard in person. A and B with the any party may be the accompanied representative of the with the attorney with the representative of the designated with the part of the examiner the attorney with the representative of the name of the proceeding governed by this part. Attorney representative who representative of the respondent with the previously filed with the pleading of the matter of the file note of the appearance of the action and the matter taken in 1503-429 must serve with a copy of the notice of appearance on each party in manner 1503-409 before participating in the process proceeding governed by the subpart of the attorney representative must include the name and address, the telephone number of the attorney representative with the notice of appearance. 1503-607, administrative law judge. Powers of the administrative law judge, according to the rules of the subpart, administrative law judge may give the notice on hold with the pre-hearings, conference with the hearings, issue scheduling orders, or other appropriate orders regarding discovery on the other matters that come from before him and the consent with the rules subpart. 3. Administrative of the oath and the affirmation. 4. The issue of subpoenas authorized law. 5. Of the rules or other officers for the proof of the 6. The receive of the relevant material evidence. 7. Regulate the course of the hearing in accordance with the rules of the subpart. 8. Withhold the conference itself with the simplify with the issue with his own motion, consent with the parties, rule and procedural motions, and require the 10. Making findings, facts, conclusions, law with the issue with the initial decision. 11. Strike unsigned documents and live with the commission with a signature with the corrected profile properly after they had been called with the attention of the attorney and the party order payment of the witness fee with the accordance of 1503-649. B. Limitation power junction law judge. The junction law judge may not issue in the order of the contempt of the award the cost of any party imposed the sanction not specified with this part. 4. With the adopt and file with the stand proof of the proceed with the contrary with the set forth in this subpart. 5. Decide issuing violation of the TSA regulation order of the requirement under the U.S. Constitution, Administrative Procedure Act, or other, if the adjunction administrative law judge imposes any sanction for the necessary of the subpart part filed with the interlocutory appeal of the right pursuant with the 1503-631C3. The section does not include the adjunction administrative law judge from the issuing over the order that bars a person from the specified proceeding based on the finding of obstreperous and disruptive behavior in the specified manner. Disqualification injunction law judge may disqualify his or herself with the head of party in the following motion pursuant with the 1503-629-5-6. F6 requesting a administrative law judge to disqualify the proceeding. 1503-609 complaint with the following with the agency for the attorney must file with the complaint with the enforcement docket clerk according with 1503-429 with the may file with the written notice pursuant 1503-629 F2-1 instead filing complaint no later than 30 days after the receipt of the agency for the attorney required for the hearing. The agency for the attorney suggest the location of the hearing with the filing with the complaint. B. The contents of the complaint with the may set forth the facts alleged any statute regulation of the alleged violation of the respondent proposed civil penalty sufficient detail to provide notice of factual legal allegation proposed civil penalty. 1503-611 answer for the filing with the respondent must be the written in compliant with the accordance with 1503-429 may be the file written motion pursuant with 1503-629 F1 through 4 instead of the filing an answer no later than 30 days after the receipt of the complaint with the subparagraph C with the section with the answer for the may file with the form of the letter must be the date and the sign with the person responding with the complaint with any answer for written may be legibly handwritten. Person filing any of the answers subject to the location of the hearing of the final answer, the contents of the answer specifically state with an affirmative defense. The respondent intended to insert the hearing with any person filing with the answer may include with a brief statement of the relief of this requested answer. C. Specify the denial allegation required of the person filing with the answer for the must admit with the denied statement of the person without sufficient knowledge of the information admit with the deny any with the use of the number paragraph of the complaint with the statement of the allegation contained with the complaint does not specifically deny with the answer must deem the admission with the truth of the allegation with the general denial of the complaint deemed the failure to file an answer. D. Failure to file an answer. Person failure to file an answer without good cause and determined by the administrative law judge to deem the admission with the truth of the allegation contained in the complaint. Our 1503-613 consolidation separation cases. Consolidation, two or more actions involving the common question with the law and the facts. Chief of the administrative law judge may do the following. One, order a joint hearing trial with any each of all such question. Two, for the order consolidation such action. Three, otherwise such words concerning with the proceeding as maybe they didn't intend to avoid unnecessary cost and delay. B. Consolidation should not affect the applicability of this part. Consolidation, two or more action individually made with the judicial amounts set forth in 1503-601. A2 with the shall not cover the resulting consolidation action to take come on exclusive of the jurisdiction district courts of the United States specified in Title 49 U.S. State Code 46301 D4A. Separate trial with the chief of the administrative law judge furtherance for the conveyance of the jury to avoid prejudice within separate trials will be conducive with the expedition and economy may order a separate trial of or any of any claim and other separate issue or any other number of claims or issues. 1503-615 notice for the hearing. Notice for the administrative law judge must give each party at least 60 days. Notice for the day of the time, location of the hearing, the consent of the administrative law judge. Part of the may agree with the hearing will following yearly date of the day specified in the notice for the hearing. Day of the time and the location for the hearing of the administrative law judge of the proceeding that has been assigned with the May 7th, the reasonable date and the time and location of the hearing with the administrative law judge, consider the need with the discovery, the joint with the procedure with the discovery schedule submitted with the party with the determined hearing date. Administrative law judge must give due regard to the main of the party with the location of the majority of the witness resides to the work with the location and serve with the schedule of the carrier. Our 1503-617 extension of time or equivalent party may agree with the extent of the reasonable time with the filing with the document and so part of the parties with agree with the administrative law judge must grant one extension for the time that each for the part of the party seek with the extension of time must submit the draft of the administrative law judge to the signed administrative law judge follow with the enforcement not clear with the administrative law judge may grant additional or equivalent extension time with the parties agree with the extension. Be written motion with the party must file with a written motion with extension for the time no later than 7 of the days before the document due with the parties with the show with a good cause of the filing. Administrative law judge may grant the extension of time party show with a good cause. C. With the request of the continuing a hearing with each party may request for the written note of continuation of the day of the hearing good cause shall no later than 7 of the days of the schedule of the day of the hearing with a good cause does not include the scheduling conflict involved with the parties their attorneys which due diligence they could have been foreseen. Failure to rule the administrative law judge failed with the rule written motion with extension for the time of the date of the document with due with the motion with extension for the time of the deed with the granting no more than 20 days for the original date of the document. Failed with the administrative law judge rule with the request of the contingency for the scheduled hearing date with the request of the deemed granted with no more than 10 days after the scheduled hearing date. 1503-619 intervention person may file with a motion and leave with the intervention with as a part of the civil penalty action person must file with a motion and leave with the intervention not later than 10 days before hearing unless person should cause for late filing. B. Administrative law judge found that the intervention was unduly broad in issue for the delay of the proceeding with the administrative law judge may grant with the motion and leave it to intervene. A person will be bound by any other decision entered within the action or the person property financial for the other legitimate interests that may be not interested adequately by the party of the administrative law judge may determine the extent in which intervener may participate in the proceedings. 1503-621 amendment to pleading filing with a service party may file with amendment and enforcement document must serve with a copy of the amendment with the administrative law judge part of the proceeding with the time of the party must file with amendment of the complaint of the answer of the following no later than 15 days before the scheduled preheating with the party may amend with the complaint with no after with an answer without administrative law judge. 2 less than 15 days before the scheduled date of the hearing, administrative law judge may allow the amendment of the complaint on or an answer only with a good cause shown with a motion to amend. C. Response to the administrative law judge may also allow reasonable time with no more than 20 days of the day of the filing. Other parties respond with amendment with the compliant answer for the other pleading with the file with the administrative law judge. Our 1503-623 withdrawal of the complaint requested with the hearing. Any time before during the hearing with the agency attorney may withdraw of the complaint with the respondent withdrawal of the request of the hearing with the consent of the administrative law judge of the agency of the attorney withdrawal of the complaint with the party withdrawal of the request of the hearing with the answer of the administrative law judge must dismiss the proceeding under subpart breach unless the withdrawal of the party should go and call for the dismissal of the prejudice, except if the party withdrawal of the request of the hearing without prejudice at the time for a complaint was filed. 1503, Section 25 of the waiver that any rights provided by the statute regulation must be written within the stipulation made at a hearing that enter into the recording parties must set forth and proceed precise time in the waiver that any of the condition. Alright, 1503, Section 27 of the joint procedure with the discovery schedule. The gentlemen of the parties may agree with the schedule with the filing all pre-hearing motions scheduled with the conduct with the discovery proceeding, or the schedule will govern all pre-hearing motions discovery in the proceeding. B, for the form of the content and schedule of the parties agree with the joint procedure for the discovery schedule. One party must follow the joint schedule with the administrative law judge setting forth the dates of the which of the parties have agreed must serve with a copy of the joint schedule on each party. 1. The joint schedule must include, but not limited to, the request for the discover the object, for the discover the request for the respond for the discover the request. If there are no objections, submission for the pre-hearing motions, respond to the pre-hearing motions, exchange of exhibit to be introduced in the hearing, list of the witness that can be called at the hearing. 2. Each party must sign with the original joint schedule to be filed with the enforcement docket clerk. C. With the time, parties may agree with the submit with the pre-hearing motion on the respond for the may agree with the cause of the disclosure for the proceeding under the joint schedule for the reasonable time before the day of the hearing. No later than 15 days of the hearing, order to establish joint decision. The administrative law judge must approve joint schedule for the file with the party. With one party must submit with the draft or over the establishing joint schedule. The administrative law judge to be signed with the administrative law judge file with the enforcement docket clerk. Disputes. Administrative law judge must resolve the dispute regarding the discovery of the dispute regarding complying with the joint schedule for the possible for the party to continue with the comply with the joint schedule. Sanctions to failure to comply with the joint schedule. If the party failed to comply with the administrative law judge's order to establish the joint schedule, the administrative law judge may direct the party to comply with the motion, discover the request, if limited to the extent of the particular party's failure. Comply with the motion, discover the request of the administrative law judge may do the following: strike the portion of parties pleading, preclude pre-hearing discovery motions of by that party, preclude admission for the portion of parties evidence for the hearing, party preclude the portion of the testimony of parties witnesses of the hearing. 1503, 629, motion of the party applying with the order ruling that specifically provided with this part must do so by motion. Party must comply with the requirements of section 1 filing A. Party must serve with a copy of each motion on each of the party form of the contents. The party must state with the relief of shot by the motion particular ground supporting the relief of the party with the evidence with the support of the motion. The party must attach any of the supporting evidence, including affidavit of the motion. C. Filing motions made private of the hearing may be written or orally recorded unless otherwise agreed with the party for the good cause shown by the party must file with the pre-hearing motion. Must serve with a copy of each of the party later no than 30 days after the hearing of the motion introduced during the hearing made orally with the record of the administrative law judge directs otherwise. D. For the reply with the motion, the party must make file with the affidavit and other evidence support with the reply no later than 30 days after the serve of the written motion on the party with the motion made by the during the hearing reply with the native hearing on the record orally or in writing with the responsible time during the determined by the administrative law judge of the discretion of the administrative law judge of the movie. The party may file with a response or reply. Rulings on a motion. Administrative law judge must rule on all the motions filed with the discovery of the motion, resolve all the pending discovery of the motions no later than 10 days before the hearing. Pre-hearing motions. Administrative law judge must resolve all pending pre-hearing motions no later than 7 days before the hearing. Administrative law judge issue the ruling in order orally. Administrative law judge must serve with a written copy of the rule order within 3 days each of the party. All other cases, the administrative law judge must issue the ruling order issuing in writing and must serve with a copy of the ruling order in each part of 3. The motion made with the during the hearing. Administrative law judge may issue the ruling with the order of the motions made with the during the hearing orally with the orally rulings orders. Motions must be made with the record of the specific motion. Any party must fail with the not limited to following motions, enforcement docket, location, clerk. Alright, 1. Motion to dismiss the insufficiency. Respondent may file with a motion to dismiss of the complaint with the insufficiency instead of the filing the answer. Administrative law judge denies the motion with the dismiss of the complaint with the insufficiency. The respondent must file with the answer no later than 20 days after the serve of the administrative law judge. Now with the motion to dismiss of the complaint with the insufficient motion must show complaint fails the state violation of TSA requirement. Administrative law judge grants the motion to dismiss complaint for insufficient agency. Attorney made amendment of the complaint in accordance with 1503 joint 1. 2. The motion to dismiss. A party may file with a motion to dismiss the specified on the grounds of the dismissal of the administrative law judge. Agreeing with the motion to dismiss, any of the party may appeal with the administrative law judge ruling on the motion to dismiss 1503 63 1B. 1. Motion to dismiss the request of the hearing for a hearing. Agency attorney may file with a motion to dismiss the request for a hearing untimely instead of the filing complaint. The motion to dismiss if it is not granted, the agency attorney must file a complaint, must serve with a copy of the complaint in each of the party no later than 20 days after the serve of the administrative law judge ruling order diminished and dismissed. If the motion to dismiss is granted, the proceeding of the terminated without hearing, the respondent may file with an appeal with the 1593-657. Whoever the decision appeal with the agency, the attorney more than file a complaint must serve with a copy of the complaint at each party no later than 30 days after each of the service of the decision of the appeal. 2. The motion to dismiss the complaint with the respondent may file with a motion to dismiss the complaint with instead of the filing of the answer on the ground of the complaint with it was not filed on the other ground the administrative law judge does not grant the motion to dismiss. The respondent must file with the answer. Must serve with a copy of the answer for each of the parties no later than 30 days after the serve of the administrative law judge rule or any motion to dismiss. If the administrative law judge grants the motion to dismiss the proceeding, the terminated with the hearing of the agency attorney may file with the agree to pursue in 1593-657. If the required decision appeal with the respondent must file with the answer, must serve with a copy of the answer for each of the parties no later than 20 days after the serve of the decision of the appeal. If the read a motion dismissed based on settlement, party may file with a motion dismissed based on a mutual settlement of the parties. 3. Motion for a more definite statement, and a party may file with a motion for the more definite statement that pleading with the required of the respondent with the under the support of the department set forth the detail of the identified with the uncertain allegation contained with the complaint with the respondent and pleading may submit with the detail of the parties with the belief of which making the allegation respond with a definite insert in complaint. The respondent may file with a request with a more definite statement over the allegation contained with the complaint with instead of the filing the answer or of filing an answer. Administrative law judge grants the motion. Agency attorney must supply with a more definite statement no later than 15 days after the serve of the rule granting the motion. Agency the attorney fails to supply more definite statement. The administrative law judge must strike allegations in the complaint to which the motion is directed. The administrative law judge denies the motion. Respondent must file an answer. Must serve with a copy of the answer for each of the parties no later than 20 days after the service of the order of the motion. 2. For the answer of the agency, with the attorney may file with the request of the most definite statement. The answer failed to respond clearly. Allegations of the complaint, administrative law judge granted the motion. Respondent must supply with a more definite statement than no later than 15 days after the service of the ruling of the motion. If the respondent fails to supply with a more definite statement, the administrative law judge must strike with a statement of the answer of which the motion is directed. If the respondent fails to supply more definite statement and more deemed with the admission of the unanswered allegations of the complaint. 4. Motion to strike. Any party may move to strike the insufficient allegation for the defensive and the redundant, immaterial, and irrelevant in the matter of the pleading. The party must fail with a motion to strike before response is required under pair of the subpart. If the response is not required no later than 10 days after the service of the plead. Motion of the decision party may move the decision regarding any of the part of the proceeding and even the administrative law judge had issued the initial decision proceed with the main part, but included the motion of the decision affidavits as well with the other evidence of the support of the motion. Administrative law judge must grant party motion of the decision pleading of the deposition into the interrogatories administrative affidavit the plan of the administrative law judge officially noted the evidence introduced during the hearing showing that there is no genuine issue of the material matter of fact. The party making the motion is entitled with the decision of the matter of the law of the party moving the decision of the burden and showing that there is no genuine issue of the matter of fact. 6. The motion disqualification part was this motion for disqualification. A party must file with a motion any time with the administrative law judge evidence of the proceeding must make with a motion the administrative law judge file with the initial proceeding with the proceedings. 1. A motion of support affidavit of the party must state with the ground of the disqualification include but not limited to personal by with the precautionary interest of the other factors supporting the disqualification. The motion of the disqualification party must submit an affidavit of the motion of disqualification set forth in detail of the matters alleged. Could say grounds of the disqualification. 2. For the answer for the must respond with the motion of disqualification no later than 5 days after the service of the motion of disqualification. 3. Discussion of the motion of disqualification. Administrative law judge must require decision must motion disqualification no later than 20 days of the motion has been filed with the administrative law judge fine with the motion disqualification supporting the affidavit is based on the disqualification. Administrative law judge must withdraw the proceeding immediately. Administrative law judge finds disqualification is not warranted. Administrative law judge must deny the motion stated that the grounds of the denial of the record. Administrative law judge failed the rule on the party's motion for the disqualification within 20 days of the motion has been filed with the motion is deemed granted for the end for appeal of the party of the administrative law judge's denial of the motion of disqualification according to the 1503-631B. Alright, 1501-631 interlocutory appeals. are general, unless otherwise provided. So the party does not appeal for the ruling with the decision of the administrative law judge, the TSA with the decision maker with the initial decision entered within the record of the decision, or with the TSA decision maker an interlocutory appeal does not constitute final order of the administrative purpose of the judicial appeal review under Title 49 U.S. Standard Code 46.110. Interlocutory appeal for cause. The party have the written equivalent of interlocutory appeal for the case of the administrative law judge, or equivalent of interlocutory appeal for the cause of the proceeding. State with the administrative law judge if the decision with the request of the administrative law judge grant with the request proceed with the state with the TSA with the decision making an issue the decision with interlocutory appeal. Administrative law judge must grant the interlocutory appeal with the case of the party show with the delay with appeal with what is determined the public interest of the result with the unduly judicious prejudice any of the party. See interlocutory appeal of the rights of the party appeals of the appeal of rights. The party of the administrative law judge interlocutory appeal of the right of the proceeding with the TSA with the decision maker issue the decision on the interlocutory appeal. Party may file an interlocutory appeal without the consent of the administrator before the initial decision entered the following cases. One, a ruling order administrative of the judge, law judge barring a person from the proceeding, failure to administrative law judge domestic and proceeding according to 1503-623. Ruling order administrative law judge violation 1503-607B, and a rule of the administrative law judge regarding public access to particular documents or docket. B. Procedure with no later than 10 days after the administrative law judge forming a base for the interlocutory appeal with no later than 10 days for the administrative law judge decision granting interlocutory appeal with the call of the priority must file with a notice for the interlocutory appeal with the supporting documents for the party must serve with a copy of the notice with the supporting documents for each of the party. No later than 10 days after the serve of the appeal brief of the party for the file with the repeal brief, if any of the party must serve with a copy of the reply of the brief of each of the party. TSA decision maker must render the decision interlocutory appeal with the record of the party with the decision proceedings with the responsible time received with the interlocutory appeal. C. Frivolous appeal for the TSA decision maker may reject frivolous, repetitive, dilatory, may issue the one other precluding one or more parties may further interlocutory appeal proceedings if they are frivolous, repetitive, dilatory, intellectual prepared. Alright, 1503-633, discover the initiation. Discover the party may initiate the discover the describing the section without the concept of the approval of the administrative law judge of the name time the complaint has filed for the proceeding. B. Method of discover the following method of discovery permitted under the section disposition, oral examination, written question with the name of the person, written interrogatories, interactive with the party. Request the production of the document tangible items to any of the person request the emission of the part of the party not request the written to discover the request of the respond with administrative law of the enforcement docket clear in the event with the disposable disclosure. Every dispute with the party must attach a copy of the document support with the motion made under the section. C. With the service of the agency must serve the search. Serve each discovery request directed to the agency or any agency employee on the agency's attorney record. RD time of the respondent to discover the request unless otherwise regret the party agree with the party with the order of the administrative law judge party responds to the request of the discovery, including the found with the objections, request the discovery no later than 30 days after the service of the request. The scope of the scope is subject to the limits of the discovery set forth in paragraph F of the section of the party with the discovery any of the matter not privileged or relevant subject matter of the proceeding. The party must discover the information related to the claim of the defense of any of the party, include the existence, description, and nature of the custody of the condition, and location, any of the documentation of the tangible, identify with the location of any of the person, knowledge of the discover the matter. Party may discover the facts of the known options, opinions held by an expert with any other party experts that call to testify for the hearing. Party may not object to discover the request of the basic information sought will not be admissible if the hearing with the information sought discover that is reasonably calculated to leave with the discover the admissible evidence. F. Limiting discovery. The administrative law judge must follow the frequency and extent with the discovery permitted with the section of the party shown with the information required for the cumulative of the repetitive, the information required that can be obtained with another less burdensome and a more convenient source. The party requesting information has ample opportunity to obtain the information for the other discovery methods under the section, and for the method to scope of the discovery requested by the party is unduly burdensome and expensive. G. The disclosure of sensitive security information. The request of the party with the TSA sensitive security information party with the sole creation with the TSA with accept the sensitive security information necessary with the party with the prepare response to allegations contained in the complaint. The TSA must provide such information subject to the restriction further disclosure safety regarding requirement the TSA determines appropriate. It's confidential order of the party or person who received the discover the request for the information, sensitive, security of information related with the trade secret, confidential, sensitive, material, competitive with commercial information, proprietary data, information on research and development may file with the motion confidential over the administrative law judge must serve with a copy of the motion for the confidential each of the party of the party. When the party making the motion show the confidential order of the necessary for the protecting the information disclosure for the public. The administrative law judge determine the request for part of the necessary for the decide with the cause of the precluded by the inquiry of the matter by any party. 3. The administrative law judge determine the request of material may be disclosed by the discovery. The administrative law judge may over the material being discovered, disclosed, and limited conditions may be used only under certain terms and conditions. 4. The administrative law judge determine that the request of material is necessary to decide with the case and that the confidential order is warranted. The administrative law judge provide with the following: 1. An opportunity to review the document by the parties off the record. Procedures excluding the information from the record, and any or parties must discover the information in a manner that the party does not use the information in any other proceedings. Protective order. That any person who receives the request to discover the file with a motion protective order must serve with a copy of the motion protective order of each of the part of the person make the motion show with the protective order necessary for the protective of the party with the person annoyance, embarrassment, oppression, undue burden, expense, and part of the protective order. Administrative law judge to deny the discover the request to order to discover the conduct and only the specified the term and condition, including the designation of the time and place for the discover the determination method of the discovery. Limit discover the precluded and inquiry with the certain matters of the discover the J. Duty supplement with the amended response of the party of the response of the discover the request for the duly supplement with the amended response of the information known as the one party must supplement. Many any respect for the question requesting and identify with the location of the person with knowledge of the discovery the matter of the party must supplement. Amend respond with the question the requesting and identify with each of the person who is qualified and called to testify at the hearing of the expert witness of the subject of the matter of the substance. Witness testimony and party must supplement order amended any response with the correct or made any response that was correct must be no longer correct or accurate and complete. Arcade depositions. The following rules must apply with the deposition taken pursuant to section 1. Form the deposition may take with the record of the reduce of the writing of the person being deposed with the must sign of the deposition unless the parties agree with the waive of the requirement of the signature administrative of the oaths within the United States with the territory possession subject to the jurisdiction of the United States with the party must deposition before the person authorized administrative of the oath laws of the United States with the authorized by the law of the place. The examination is heavily outside of the chamber of the party with the taking of the deposition in manner with the file with the federal rules of civil procedure for the Title 28 U.S. Standard Code Appendix. For the deposition party with the must serve with the notice for the deposition stating with the time and the place for the deposition, name and the address for each of the person to be examined on the person to be disposed. Administrative law judge of the enforcement docket clerk on each part with the no later than 7 days before the deposition. Party must serve with the notice for the deposition less than 7 days before the deposition. Only concerned with the administrative law judge of the good cause shown with the subpoena with the UCS tacum. We serve within the person to examine the party serves attached with the copy of even the tanium to discover the material that produce the deposition and notice of the deposition. For the use of the deposition, party may use any of the part of the deposition here with the authorized and the subpart only with the term of the good call of the question. Deposition may be used against for that person with the present the representative of the deposition who had reasonable notice of the deposition. IL interrogatories. Party or parties attorney with the third party's representative may serve on the party with the response with the interrogatories. The party may answer the interrogatory separately and completely in writing with the party objective. Interrogatory. The party may state the objection and the reason for the objection. The opposing objection may also, with all of the parties respond with the investigatory hearing authorized and subpart extend with the response with the relevant material with the non-repetitious. Party may not serve the 30 interrogatories, however, each of the subpart of the name of the interrogatory count separate interrogatory. For serving the additional interrogatory part of the party must follow the motion and leave it to serve the additional interrogatories. Part of the administrative law judge must serve the copy to each of the party of the serve the additional interrogatories on the part. Administrative law judge may grant with the motion only if the party show the good child with the proper field with the inquire with the information previously information cannot reasonably be obtained unless burdensome discovery methods to obtain from others over the request for admission. A party may serve the written request for the truth of the matter, the discovery of the section, and the authenticity of the document described in the request. The party set forth the request of the admission separate from the parties must serve the copy of the documents that reference for the request of the administrator of the admission unless the documents have been provided reasonable available to the inspection of the copy at the time. Parties failure to respond on the request of the admission, writing in the sum of the attorney of the party no later than 30 days after the service of the request and deemed with the admission with the truth of the statement contained with the request of the admission, the administrative law judge may determine the failure to respond on the request of the admission with the not deemed admission of the truth. The party failed with the failure was due to the circumstances beyond the control of the party's attorney. 2. Respond. The party may object with the request of the admission, must state with the reason for the objection. The party must specifically deny with the truth of the matter, with the describe of the reasons why the party is unable to truthfully deny or admit the matter. The party is unable to deny or admit the truth of the matter. The party must show that the party has made reasonable inquiry into the matter of the information known or readily obtained with the party is insufficient and able to admit with the deny the matter of the party may admit to deny any of the party request of the admission. The administrative law judge determine the response does not comply with the requirements of the rule. The response in position matter with the deemed admitted with the see the effect of the admission. Any matter admitted deemed admitted under the section is conclusively established for purpose of hearing and appeal. And the motion will compel to discover the party move the discovery of the motion. A person refuse the answer to the question, the disposition of the person fail to refute the answer, interrogatory person give the evasive, incomplete answer for the desiring the deposition, responding to an interrogatory. Party fail to refute the produce every document, tangible item during with the deposition proponent of the question, complete with the deposition with the maturing with the expiration move of the complaint. Compel person refused to answer, failure to comply with the discovery order to compel parity, fails to comply with the discovery order to compel. Administrative law judge limited to the extent of the party's failure to comply with the discovery order motion to compel doing the following: strike with the portion and parties pleading, preclude hearing with the discovery the motions about the party, preclude admission with the portion of the party's evidence at the hearing, preclude the portion of the testimony parties here witnessing at the hearing. Alright, 1500-3635, evidence. General, the party within tell the parties gave the defense of the oral documentary to demonstrate with the evidence, with the rebuttal evidence, the conduct with the cross-examination, they recover the full and truthful state and disclosure of the facts, admissibility, preliminary the oral document, demonstrate with the evidence, support of the parties gave the defense of the administrative law judge must admit oral documentary to demonstrate with the evidence, including the truth by party, but may exclude the irrelevant, immaterial, with the unduly repetitive evidence. Here we say the evidence, hearsay with evidence, admissible, the proceeding governed with a subpart of the fact. Evidence submitted by parties of the hearsay shall go only to weight with the evidence does not affect the admissibility. 1503-63-7 standard of proof. Administrative law judge may issue an initial decision, may rule in parties' favor only on the decision ruling in support of the preponderance of the evidence contained on the record in order to prevail of the party with the burden of proof was reviewed of the parties gave the defense a preponderance over the evidence. 1503-639 proof, burden of proof. Separately gave the affirmative the defense of the burden of proof is on the agency, except for the otherwise provided the chaser with the rule proponent motion request or order as the burden of proof. See if the party has asserted that the affirmative defense has provided burden of proof of the affirmative defense. 1503-641 order of proof of the party whose evidence has included with the rule administrative law judge may offer the evidence with the record of the appeal. 1503-643 public disclosure of evidence apply with the information security sensitive the information security all security sensitive information. 1503-415 until 49 CFR 1520. Administrative law judge may order any other information contained in the record withheld by the public disclosure. Person may reject with the disclosure information required in the record by written motion without or to withhold specific information. Administrative law judge serving the copy of the motion on each of the party. Party must state with a specific ground for the disclosure of the motion. Administrative law judge grants motion withheld the information record based on the motion and respond to the motion. Administrative law judge the disclosure would determine instrumental grants patient safety. Disclosure would not be in the public interest of the information not otherwise required to be made available to the public. 1503-643 experts of opinion witness employed with the agency not called in as expert option witness any other of the TSA with the proceeding government with the subpart with the employee with the respondent may include in agency and attorney expert option witness TSA proceeding governed by the subpart with the respondent to the party. Alright, 1503-647 is for subpoenas. Request for a subpoena. A party may obtain a subpoena to compel the attendance of the witness for the depositing a hearing, require production of the document of tangible items for the administrative law judge's assignment of the case of the administrative law judge's assignment of the signed law judge is unavailable to the chief of the administrative law judge. Party must complete the subpoena statement the title of the action on the date of the time of the witness attend with the production of the documents for the item the party was obtained submitted. Subpoena must serve the subpoena witness for the custodian of the document tangible item top of the produce. Motion of the quash or modify the subpoena party or any person with the submission has served the motion of the quash or modify the subpoena and perform the time specified subpoena complying with the application of the describe the basis for the application of the quash modify supply subpoena included but not limited to the statement that the testimony of the document tangible evidence not relevant to proceed with the submission does not reasonably tailor the scope of the proceeding. Subpoena is reasonable and unpressed with the motion of the quash and modify the subpoena will still in effect with the subpoena proceeding pending decision administrative law judge on the motion. See enforcement of the subpoena upon showing that the person has failed to refuse to comply with the subpoena with any part of the U.S. District Court having the jurisdiction of judicial enforcement and subpoena in accordance with Title 49 U.S. Code 46.104. 1503-649 witness fee with the general. We, unless otherwise authorized, administrative law judge or person or party who apply with the subpoena to comply with the attendance of the witness for the deposition here with the party who's required for the witness appear with the deposition here with the must pay with the witness fee described in this section. Be the amount except for the employee with the agency who appear with the direction with the agency, a witness who appear with the deposition here with the entail with the same fees and mileage expenses as are paid to the witness for the court of the United States with comparable circumstances. RC 1503-651 record. Exclude the record of the record. Request of the hearing compliant with the answer for the transcript of all of the testimony of the hearing. All extra. Exhibit the receipt of the evidence. All the motion. Respond for the motion. The application. The request of the rulings. The counts for the exclusion for the records. Record of the decision proceedings. Over the base for the issue of the aim of the orders of the proceeding. B. The examination copy of the record. Generally, any person interested in the receipt of the obtainment of the copy of the record to be due for the submitted into the Freedom of Information as required for the Title 5 U.S. Standard Code 552, 10 Sequence 49, CFR Part 7. Any applicable Department of Homeland Security regulation portion of any of the record may be exempt from the disclosure pursuant to the Freedom of Information Act. Dockets of the docket or filed documents are not for public disclosure. On the following person may review the docket file of particular documents that are not public disclosure party to the proceeding. There's designated representative of the person may need to know determined by the administrator. 2. Person permission to review the documents. Document files may view the material of the TSA headquarters 601 South 12th Street, Arlington, Virginia 20598 6002. Person access for the records may comply with the records after the payment of reasonable costs. Alright, 1503-653, argument by administrative law judge from integrative law judge during the hearing. The hearing with administrative law judge give the party the reasonable opportunity to present the arguments for the report supporting oppressive objects, opposing motions, objections, ruling of the parties that they request for the objection and proper to the agreement. The administrative law judge may request for the written agreement. Argument during the hearing with the administrative law judge, the submission written argument necessary for the before administrative law judge if the reading the ruling of the order. Final oral argument. The conclusion of the hearing before the administrative law judge, the initial decision proceed with the parties and entitled to submit the oral proceeding, proposed findings of facts and conclusion of law, exemption of the rules, administrative law judge supporting agreement before finding the conclusion, exemption, conclusion of the hearing. The party may waive final oral argument. See post briefings, post-hearing briefing. The administrative law judge may request the post-hearing briefing before administrative law judge issued the initial decision with the proceeding. The party filed with the post-hearing briefing. The party must include the post-hearing proposed finding of the fact, conclusion, law, substantive rule. The administrative law judge and the supporting argument of the finding of the conclusion, exemption. Administrative law judge give the party the reasonable opportunity no later than 30 days after the receipt of the transcript of the prepared submitted briefs. Alright, 1503-655, initial decision. Contents administrative law judge may issue the initial decision conclusion of the hearing after the submission of the written post-hearing briefing. In order to each oral written decision, administrative law judge must include the fact conclusion of the law's grounds supporting those finding the conclusions upon material issue, fact, credibility of the witness, applicable law, exercise administrative law judge discretion, and amount of the civil penalty found with administrative law judge discussion on the basis of any order of the proceeding. Administrative law judge not provide with a written explanation of the rules, objections, procedural motions, other matters not directly relevant to the substance of the initial decision. Administrative law judge refers to any previously unreported, unpublished initial decision. Administrative law judge makes copies of the initial decision available to all parties. Transition TSA decision into the TSA decision maker. Okay, written decision and the conclusion of the hearing with the administrative law judge have the initial decision. Order orally, record of the administrative law must issue the written initial decision no later than 30 days of the conclusion of hearing submission with the below as post-hearing brief of the administrative law judge must serve with a copy of the written initial decision of each part. Order assessing civil penalty unless other appeal pursuant to 1503-657 initial decision issued the administrative law judge consider the order assessing civil penalty administrative law judge find alleged violation occurred determination civil penalty and amount found an appropriate administrative law judge warranted in effect with the initial decision administrative law judge pursuing the authority within civil penalty action and appeal with the preserve the Tuesday decision making in court of competent jurisdiction. And then we're moving on. Alright, 1503-657 appeal with the initial decision. Notice of the appeal, each part of the master appeal, the initial decision did not previously apply with the 1503-631, filed with the notice of appeal with the enforcement docket for the party with the file with the notice of the U.S. Coast Guard, administrative of the junction law judge, docketing civil the intent enforcement docket clerk, 40 South Gay Street, room 412, Baltimore, Maryland, 21202. Party must file with the notice of the appeal no later than 10 days after the entire initial decision on the record, serve with the written initial decision record, serve with a copy of the notice of the appeal. Each party on file with the notice of the appeal, effective with the initial decision, state with the final decision, or with the TSA decision maker evidence of the record. B. Issue for the appeal, the party may appeal with the following issue of the right, whether each finding of the facts supported preponderance of the evidence, whether each of the conclusion law made in accordance with the applicable law, precedent, and public policy, whether the administrative law judge committed any prejudicial errors during the hearing of the support of the appeal. C. With the perfecting an appeal with unless otherwise agreed with the parties must perfect an appeal with not later than 30 to 50 days after the entry of the oral initial decision of the record, and serve with the written initial citizen party with the final appeal brief and the enforcement docket clear with extension of the time of agreement of the parties may agree with it at each end of the time of perfecting appeal. Consider the TSA the decision maker of the CSA dismissal granting extension of the time of the perfect appeal. The enforcement document will serve with a letter conforming the extension of the time of each party. Written motion of the extension of the party does not agree with the extension of the time of the perfecting appeal of the party desiring with the extension of the time. Written motion with the extension of the enforcement document clerk must serve with a copy of the motion on the party. On each part of the TSA with the decision maker of the grant extension with a good call with extension with the showing the motion. C. Appeal with a brief. The party may file with the appeal brief with the enforcement document must serve with a copy of the appeal with the brief on each party. And the appeal brief of the party may set forth the detailed party specific objection with initial decision and rulings are based on the appeal with the reasons supporting the appeal with the relief of the question with the appeal with the party relief of the evidence connected to the record of appeal. Party must specifically appeal with the brief the pertinent with the evidence contained in the transcript. TCA the decision makes a dismiss and appeal with the TCA but the decision makes an issue with the upon motion any other appeal party in the file with the notice fails to perfect an appeal with the timely brief brief. A reply brief unless otherwise agreed by the party may file with a reply brief no later than 35 days after the brief appeal brief has been served on the party file when the repeal brief must be preserved with a copy of the repeal brief and on each of the party reply with the evidence contained in the record of the reply. Party must specify the referred to pertinent evidence contained in the transcript of the repeal of the brief. Extension of the time of agreements of the party must agree with the extent of the time of the repeal with the consent with the TCS, the Transportation Security Administrator, the decision maker, the TSA, the decision maker grants extension of time. File with the brief and enforcement document clerk will serve with a letter conforming the extension of the time of the party. 2. Written notice of motion of the extension of the party does not agree with the extension of the time of the following with the repeal or brief the party decision. Extension of the time made with the written motion. Extension of the serve with a copy of the motion. Each of the party TSA decision making the grant extension with good call with extension shown in motion. After the other briefs, TSA, the decision making in and allow any proof of the ambitious crew brief and an appeal with the initial decision party filed with the one over the brief, the reply brief of the party petition with the TSA decision. Writing to leave an additional brief that must serve with a copy of the petition. Each party of the party may an additional brief of the position of the TSA with the decision grant leave with an additional brief within the party. Demonstrates good cause with an additional argument with an appeal with the TSA decision maker will allow reasonable time for the party to do. File additional brief. The number of the copy of the parties may file with the original brief, the original reply brief, and 2 copies of the brief of the enforcement document card. Oral argument of the TSA decision maker with the sole discretion on the oral argument on the appeal with the decision made and issue with upon the written motion of the party of the TSA decision maker fine. Oral argument contributed substantially for the development of the issue with the appeal with the grant parties with the opportunity of oral argument. Waivers of the objection with appeal with the party failed to object to any alleged error or regarding the proceeding with the reply with the brief party waiver the objection with the alleged error with the TSA decision maker did not require the objection and they appeal with the brief and any of the argument and appeal brief the party's objection based on the evidence of the record party but does not specify the refer to pertinent evidence of the record or of the brief. TSA decision maker in a brief, appeal on appeal of the TSA decision maker in a brief of the brief of the appeal of the oral argument and to determine the administrative law junction committed prejudicial error of the preceding initial decision should be affirmed and modified or reversed. TSA decision maker modify, apply, affirm, modify, reserve the initial decision and necessary findings and remand in case any of the preceding TSA decision maker terms may be necessary. 1. A TSA decision maker raised an issue with the TSA owns an issue with the required with the proper disposition proceeding with the TSA decision maker will give the party reasonable opportunity to support argument the new issue making with the decision of the appeal of the TSA decision maker require consideration of additional testimony evidence. TSA decision maker will remand the case for the administrative law judge proceedings. Initial decision related to the issue of the TSA decision may raise an issue with the solely issue of the law with the issue addressed at the hearing. Raised as a part of the brief of the appeal with the TSA decision maker may remain with the administrative law judge proceeding with discretion to do so. The TSA decision maker will make with a view of final decision with the administrator element of the writing serve the decision on either party and if the party reviews the pursuant. The 1503-659 final decision order of the Ministry of the orders assessing civil penalty. TSA decision maker finds the alleged violation occurred with the civil penalty warranted. 3. Final decision order of the Ministry of the appeal with the binding and the perception any of the civil penalty unless appeal with the reverse by the court competent with the jurisdiction. TSA decision maker will determine whether the decision order TSA decision maker administrative law judge initial decision task may relief of the public either the whole or reacted form making the determination TSA decision maker will consider the disclosure of any information decision order will be detrimental to transportation security would not be in public interest or should not otherwise be recorded to be available to the public. Alright, 1503-659 petition reconsider the modified final decision order of the TSA decision maker on appeal. Jesus goes on forever. Any party made with the TSA decision maker will be modified with the final decision order of the TSA may appeal with the initial decision party must file with the party. Petition reconsider the modified with no later than 30 days after the TSA decision maker with the final decision order appeal must serve with a copy of the petition. Each of the party TSA decision maker will reconsider the make an initial decision order of the administrative law judge of the appeal by any of the party TSA decision maker filed with the enforcement docket clear. Forming the number of the copy of the party must file with the petition reconsider with the modified of the party for the order petition with the enforcement docket clear must serve with a copy of the petition with each of the party contents. The party must state with a briefly with a specifically alleged error of the final decision order apply with the least assault of the party with the grounds that support the petition reconsider the modify. If the position based wholly on part of the allegation regarding consequence of the TSA decision maker's decision, part describe the support for these allegation petitions based on a whole and new part of the previously raised in the proceeding the party set forth with the newly material of the actual included affidavit of the prospective witness that if the document that would introduce support new material. Party must explain with the detail of the new material was discovered through due diligence prior to the hearing. Repetitious and frivolous petitions the TSA decision maker will consider repetitious frivolous petition the TSA decision maker similarly dismisses repetitious frivolous petition reconsidered modified. Reply petitions any party with reply with the petition reconsidered modified no later than 30 days after the service. Petition the party file the report the enforcement document clerk of the party with a the copy of the reply each part of the effective filing petition unless otherwise ordered. TSA decision maker filing petition presume the section state effective date of the TSA decision maker final decision order of appeal. Chief of the TSA, decision maker on the petition, is sole discretion to deny the petition, reconsider the modify the middle grant, but deny the petition, reconsider the modify the written response after receipt of the receipt. From pre-allow the petition, TSA may reform and modify, reverse the final decision, order, appeal, recommend the case proceedings. The decision maker determines it may be necessary. Alright, 1503-661, Judicial Final Order. Final violation TSA requirements made petition review of the final order administratively on the Court's Appeal of the United States Court of Appeal of the District of Columbia. Title 49 U.S. Standard Code 46.110, party seeking judicial review of final order may file a petition no later than 60 days after the filing order has been served on the party. Subpart H, Judicial Assessment of Civil Penalties.